Good morning, and welcome to this hearing in the Sheku Bio inquiry. One of my assessors, Mr. Raju Bhatt, will be attending the hearing remotely. The purpose of this hearing is to give the legal representatives of core participants the opportunity, if they wish, to make oral submissions. A number of core participants have already lodged written submissions, and after I have heard all the oral submissions, the written submissions will be published on the inquiry's website. The oral submissions will allow representatives to highlight or develop points made in the written submissions. Legal representatives will have up to 40 minutes to make their oral submissions. As I indicated at the end of the last hearing, the submissions at this stage are focused on the evidence about the events leading up to and including the death of Sheku Bio and the cause of death. There is, of course, still a substantial amount of evidence to be laid in the inquiry. It would therefore be premature for me to draw any conclusions at this stage, and I will not be issuing an interim report. When all the evidence is completed, core participants will have an opportunity to make final submissions on the whole evidence. The current submissions will allow me to assess the evidence laid in relation to the events and the cause of death and consider whether there are any areas which require further exploration. The oral submissions will be taken in the following order. First, Senior Counsel to the inquiry, thereafter, Counsel for the Bio families, Counsel for Police Scotland, Counsel for Ms. Short, PC Walker and the Scottish Police Federation, Counsel for Mr. Payton, Counsel for Constables Good, Smith and Tomlinson, Counsel for Sergeant Maxwell and Constables Gibson and McDonoghue, and finally Counsel for the Coalition for Racial Equality and Rights. Counsel for the remaining core participants have indicated that they do not intend to make oral submissions. I intend to take breaks at appropriate points in the course of the hearing. So can we begin with Counsel to the inquiry, Ms. Graham?
Thank you. Shortly after 0400 hours on Sunday, the 3rd of May, 2015, Sheku Bio was spending time with friends at the home of Martin Dick. During their time at Mr. Dick's property, Mr. Bio began to act differently and believed the others in the house were being disrespectful towards him. At around 0530 hours, he left the house abruptly. This was out of character. Zaid Sahid tried to find him, and they met up outside Mr. Bio's home at Arran Crescent in Kirkcaldy. Mr. Bio did not recognise him and thought he was in the CID. His eyes were switching and his personality changing. Mr. Said attempted to leave and was followed by Mr. Bio, who punched Mr. Said to the head several times and chased him with a wooden washing line pole. After Mr. Said fell, Mr. Bio punched him several times to the head, face and body. Subsequent toxicological analysis confirmed MDMA and alpha PVP in his blood and urine. The medical evidence suggests that he was suffering from psychostimulant intoxication and drug-induced psychosis. It is likely that Mr. Bio returned to his house and took a knife from a set in his kitchen. He then encountered his neighbour, Mr. Neil Morgan, in the street, and Mr. Morgan spoke to Mr. Bio and noticed he was holding a knife. He invited Mr. Bio to come back, have a cup of coffee, a cup of tea. You need to settle down. Mr. Bio replied that he was fine. Mr. Bio seemed calm, although Mr. Morgan described his eyes as starey and said Mr. Bio wasn't himself. Afterwards, Mr. Bio walked a journey of under 1 mile to Hayfield Road. Within a period of 8 minutes, between 0709 and 43 seconds and 0716 and 33 seconds, 6 emergency calls were received in the Police Scotland Area Control Room at Bilston Glen. This included calls from Mrs. Joyce at 0711, who described a black man who had a 9-inch knife in his hand, and Mr. Kohlberg, who described the man jumping out, trying to hit other cars, stopping vehicles. He said he didn't know what was wrong with him. These calls were received by the area control room and classified as Grade 1. That's defined as an ongoing incident where there is an immediate or apparent threat to life or a serious crime in progress. The ACR deployed officers to respond to the incident and continued to monitor calls and update their storm log. They continued to communicate with and listen to airwaves messages with the responding officers. At 0716 and 32 seconds, PC Tomlinson and PC Short were diverted to deal with the incident. All units were summoned, and PC Payton and PC Walker rerouted and have arrived at Hayfield Road at 0720 and 23 seconds. They were the first to arrive. At the time, Mr. Bio was walking along Hayfield Road near the bus stop. He was described as goggle-eyed, oblivious to everything else that's going on about him. Both officers got out of the van, armed with CS and Pava spray. Both shouted commands at Mr. Bio, to which he did not respond, and both officers discharged their sprays. The sprays had no effect on Mr. Bio. At 0720 and 39 seconds, reinforcements arrived in the form of PC Tomlinson and PC Short, approximately 16 seconds behind PC Walker and PC Payton. Mr. Bio walked up the nearby footpath, away from PC Payton and PC Walker, who were affected by the discharge of their sprays, and PC Tomlinson and PC Short began mirroring him. PC Tomlinson was shouting commands at the top of his voice. There was no reaction. PC Tomlinson took out his spray and adopted a defensive stance and sprayed his CS spray twice. On the second occasion, he navigated the wind direction. This had no effect on Mr. Bio. At some point, PC Short stopped and took out her baton. Mr. Bio looked at her and started walking towards her with a kind of boxer's skip. She swiped her baton towards him but did not make contact and then ran away. As she ran across Hayfield Road, she felt him behind her, and then she was hit with what she described as an almighty blow to the back of her head in the area of her ear. She was unable to stay on her feet and fell forward, putting her hands out to save herself. The next thing she remembered, she was curling up into a ball and grabbing the bun at the back of her head, trying to protect her head. She did not recall being stamped. At this point, versions diverge, and I address this in some detail in my written submissions. P.C. Tomlinson stated Mr. Byell stomped on her back with his foot with a great deal of force. He put his full body weight into the stomp and used his arms to gain leverage, then stomped on her back again with the same force, and she was not moving. He is supported to some extent by P.C. Walker, who gave evidence that he also saw Mr. Byell stamp once on P.C. Short. In response, P.C. Tomlinson struck him with his baton about 2 or 3 times in total to the head area. He also struck him 2 or 3 times with his baton to Mr. Byell's arms. On the contrary, Mr. Nelson, who lived in Hayfield Road at the time, has given evidence that the stamp and stamps did not take place. There are images available to you, Chair, created by Mr. Giovanni of Advanced Laser Imaging, of the scene from the living room of Mr. Nelson, which may assist you in assessing his viewpoint. In addition, there is medical evidence, including photographs, regarding the injuries to P.C. Short and their location. And there is forensic evidence about a mark on P.C. Short's vest from a number of experts, including Professor Dawson, who gave evidence about contact between Mr. Byell's footwear and the samples from P.C. Short's vest. I address all these matters in the detailed evidence which may either support or contradict the evidence of P.C. Tomlinson, P.C. Walker and Mr. Nelson in my written submissions. At that point, Mr. Byell was brought to the ground by P.C. Walker, who shoulder charged or bear hugged him to the ground. P.C. Short attempted to stand up, but her legs weren't working. She tried to get up again, and she saw P.C. Peyton, who came over and helped her up, and he told her to run to the van. The restraint was fast moving, but again I have addressed the detailed evidence available to you in my submissions. In short, the officers sought to gain control and pin down Mr. Byell, and he resisted their attempts. They sought to apply handcuffs and leg restraints. Mr. Byell struggled using what was described as extreme force. P.C. Walker punched him a couple of times to his face, and P.C. Tomlinson delivered 2 or 3 baton blows to Mr. Byell's Achilles area and then straddled his legs. At 07:21 and 19 seconds, P.C. Tomlinson pushed the emergency button for assistance. By the time he did so, Mr. Byell was on the ground for maybe seconds, and P.C. Tomlinson continued to sit, straddling his legs. Mr. Byell flicked his legs and caused P.C. Tomlinson to lose his balance and his grip on his handcuffs, and P.C. Tomlinson changed his position in response to this action to lie across Mr. Byell's legs diagonally to stop this movement. The first officers arrived at 07:20 and 23 seconds, and by the time P.C. Tomlinson pressed his emergency button, it was 07:21 and 19 seconds. On my calculation, this is a period of around 56 seconds. By this time, Mr. Byell was on the ground, with P.C. Tomlinson straddling his legs. CS and PAVA sprays had been discharged in his direction by 3 officers. He had been struck with a baton multiple times to the head and arms, and he had been shoulder charged to the ground. PC Peyton was the third officer to assist with the restraint. PC Peyton was located closer to Mr. Byles' head. PC Peyton had a baton and passed it through Mr. Byles' left arm to try and apply the handcuffs. PC Tomlinson attempted to apply a handcuff to Mr. Byles' right wrist, but as he did so, Mr. Byle pulled his hand forward, dragging PC Tomlinson closer to him. Mr. Byle then attempted a press-up off the ground, lifting the officers. At 21, 28 to 31 seconds, PC Smith and PC Good arrived. After attending to PC Short, PC Smith went over to assist with the restraint. PC Smith warned Mr. Byle that he would spray him with CS spray if he did not stop resisting, but was told by PC Walker that it would be ineffective. As incapacitant spray was not an option, PC Smith assisted the other officers to gain control of Mr. Byles' hands and allow handcuffs to be applied. Handcuffs and leg restraints were applied and the officers gained control. Once the fast straps had been applied, PC Smith stood up, moving away slightly. When he stood up, PC Smith checked the injuries to his hands and turned his attention elsewhere for around 30 seconds to a minute. PC Tomlinson got off Mr. Byles' legs and Mr. Byle was rolled onto his left side. PC Tomlinson then searched Mr. Byles' pockets on his right side looking for a knife. There was no knife found on Mr. Byle. Officers later found a knife in a grassy area along Hayfield Road. Officers noticed when Mr. Byle was turned onto his left-hand side that he had stopped struggling. His eyes were shut and he was moving when he was turned onto his left-hand side. His eyes were shut and he was not moving when he was turned onto his left-hand side. He was unconscious. He was unresponsive. Officers did not know whether anyone was monitoring Mr. Byles' breathing prior to them realising that he was unconscious. At 07:25 and 17 seconds, PC Smith transmitted over the airwaves. This male now certainly appears to be unconscious, breathing, not responsive. Get an ambulance for him. This was the first call for an ambulance for Mr. Byle. No additional information was given at that time, indicating that he had been sprayed with CS or PAVA or battened to the head. Dr. Carey considered that the cause of Mr. Byles' loss of consciousness was hypoxia as a result of the restraint and struggle. He explained that loss of consciousness represented a perilous situation, particularly when a person is hypoxic, unless corrected, for example, by rescue breaths, and would lead to cardiac arrest. At 07:29 and 30 seconds, Acting Police Sergeant Maxwell transmitted via the airwaves, "This accused is now not breathing. CPR is commencing." PC Walker was performing chest compressions. CPR appears to have commenced more than around 4 minutes after Mr. Byle was noted to be unconscious. PC Smith attempted to provide rescue breaths on 3 occasions with the face shield, but was aware that the breaths were escaping out of the side of Mr. Byles' mouth. At 7:32 and 11 seconds, Acting Police Sergeant Maxwell transmitted chest compressions commenced. However, breaths have stopped due to cross-contamination. PC Smith and Peyton attempted to fit a one-way valve shield into Mr. Bio's mouth, but were unable to do so. They attempted to open Mr. Bio's mouth with their fingers, but were unsuccessful. Dr. Shearer described finding injuries to this area at the subsequent post-mortem, which were consistent with those attempts. At 7:33 and 35 seconds, the ambulance arrived at the locus, and ambulance staff attended to Mr. Bio. They were unable to find a pulse and transported him to Victoria Hospital. A police officer drove the ambulance to the hospital so that both could continue working on Mr. Bio. At around 7:45 in the morning, the ambulance arrived at Victoria Hospital, where Mr. Bio was brought into a resuscitation cubicle, and medical intervention was undertaken by 7 doctors assisted by nursing staff. When Mr. Bio arrived at the hospital, his wrists remained handcuffed with leg restraints still applied, and they were removed at a doctor's request. On arrival, a doctor checked Mr. Bio's carotid artery and found a pulse. She deduced that Mr. Bio was actually in respiratory arrest. She then lost Mr. Bio's pulse and concluded that he had gone into cardiac arrest, and CPR commenced. CPR, both manual and with the use of a thumper machine, lasted for 1 hour and 14 minutes. Life was pronounced extinct at 09:04 on the 3rd of May 2015. In assessing the circumstances that day, you may wish to begin by considering the way the incident was managed by the ACR, the divisional officers, and the officers on the ground. 4 options emerged in evidence. Firstly, the RVP from the evidence of PC Peyton. Secondly, observe, wait and feedback, which came from Inspector Stewart. De-escalation, again, which was spoken to by Inspector Stewart. And finally, verbal dominance, the hard stop, from Martin Graves. You will also need to consider whether the use of force by each individual officer was justified and lawful, bearing in mind all the circumstances. You will need to ask yourself whether it was necessary, proportionate and reasonable, and whether the preclusion principle was observed and that minimum force was used. You will wish to consider submissions on fact and law and have particular regard to the use of force standard operating procedure, which was in force in May 2015, and the Officer Safety Training Manual 2013, which was also in force at that time. You may be assisted, in particular, by paragraphs 4.5 and 4.6 of the Standard Operating Procedure, which list the profiled offender behaviour, categorised levels 1 to 6, and the reasonable officer response, categorised levels 1 to 5. These were mirrored in the manual, which was in force at the time, and you have heard evidence from both PC Walker and PC Tomlinson about their understanding of these categories. That evidence alone should be sufficient to allow you to carry out that exercise if you wish, but you may go on to consider the expert evidence you have heard from Martin Graves and Joanne Caffrey. Both have given evidence. Both are in agreement that the 4 tactical options were open to reasonable officers that day, that these options could be instructed by the ACR inspector, the sergeant on the ground, or the officers themselves. They agree that all options were available to reasonable officers on that day. Both Mr. Graves and Ms. Caffrey explained the framework that existed in the use of force SOP at the time and gave examples, and that should provide additional assistance to you and allow you to compare the actions of the officers who engaged with Mr. Bio against that framework. In relation to the most recent hearing on cause of death, there appears to be consensus amongst the medical witnesses that Mr. Bio's sudden death was due to sudden cardiac arrest, contributed to by the drugs he consumed, and the restraint and struggle at Hayfield Road. Dr. Carey considered that although the death was multifactorial, the most significant factor was the restraint and struggle. He proposed an adjustment to the wording of the cause of death certified by Dr. Shearer and Dr. Bouhadir, such that it would read 1A, sudden death in a man intoxicated by MDMA, ecstasy, and alpha-PVP in association with struggling and restraint. Dr. Shearer and other doctors, including Dr. Crane, agreed with this proposed form of words. These were factors mentioned in evidence that all medics were agreed, there were factors mentioned in evidence that all medics were agreed had absolutely no bearing on Mr. Bio's cause of death. These included minor ailments, blunt force injuries, infection, excited delirium, and heart disease. Factors which may have had a bearing and upon which you have heard detailed medical evidence include the consumption of illicit drugs, restraint, and struggle against restraint. And I have addressed these matters in detail in my written submissions. In addition to the above, you have also heard evidence about sickle cell trait. Mr. Bio was a carrier of the sickle cell trait, and Dr. Carey explained that the presence of sickling in someone with that trait means they have been pushed to the limit physiologically and become hypoxic, which has precipitated sickling. He considered that the presence of sickling provided evidence of hypoxia and lactic acidosis due to restraint, and that sickling is an independent marker for hypoxia. Professor Lucas was of the view that the struggle and restraint would have caused hypoxia and acidosis. The effect of the sickling in the lungs was respiratory arrest, leading to cardiac arrest. Dr. Carey agreed with Professor Lucas that sickling developed during the restraint and struggle. In relation to sickling, Professor Lucas gave evidence that sickle cell trait should be recorded under Part 2 of the death certificate, and Dr. Shearer agreed. You've also heard of petechial hemorrhages. Dr. Shearer's evidence was that petechial hemorrhages could indicate a degree of asphyxia, either positional, being chest down, or mechanical, caused by the application of pressure to the back, which could impede breathing. Dr. Carey agreed that petechial hemorrhages could be indicative of a degree of asphyxia, specifically mechanical asphyxia, due to the application of pressure, weight, or force to the front or the back of the trunk. He was of the view that substantial force was required to cause petechial hemorrhages, and the presence of the petechial hemorrhages provided support for mechanical asphyxia. My detailed written submissions address each of the issues for consideration, particularly where that evidence diverts. You alone will have the responsibility of deciding which witnesses are telling the truth and which witnesses are accurate in their recollections. I have also addressed the guidance which is provided to you on the questions of whether the management of the event and the use of force by the officers was reasonable or excessive. I have addressed issues regarding the legal test you may apply in determining cause of death. You will now hear oral submissions from the core participants on the events that occurred at Hayfield Road and the cause of death, which follow on from their detailed written submissions which have been provided to you. and you will receive considerable assistance from them in this regard. There are two final matters I would wish to raise at this stage. As you have noted this morning, these are interim submissions. Further evidence will be laid before you in relation to matters of some significance. As a result, I would recommend that you do not form any final concluded views about the actions and states of mind of the officers pending that further evidence. Firstly, I hope to lead further evidence about training at our hearing later this year, and this may impact on how you view their actions at Hayfield Road. For example, PC Payton felt he did not have adequate training for this situation. Secondly, I hope to lead evidence about the potential impact of racial threat theory in the final race hearing next year. This may assist you in gaining a fuller understanding of the events that occurred at Hayfield Road. Thank you very much.
Thank you, Ms Graham. Next, on behalf of the families of Sheku Bayo, Ms Mitchell.
We make our submissions in the form of propositions, and we will read with interest and care the propositions of other core participants, and where appropriate make responses, either agreeing with or highlighting areas of disagreement. We do so in an effort to assist the Chair in narrowing the relevant issues for him to consider with the assistance of the assessors. As just touched upon by my learned friend, we have not finalised our position in relation to matters, as it's vital to hear all of the evidence before we make suggestions in relation to findings. Before detailing our submissions in writing, we have produced for this morning an overarching introduction. When in October 2019, the Lord Advocate advised the Bayo family that no police officer or Police Scotland would face charges for the death of Sheku Bayo, his family felt betrayed, believing there had been a failure to hold power to account, that a flawed investigation had taken place where many promises made by those at Crown and Perk were repeatedly broken over the course of a number of years. From the very day that Sheku died, his family stated that the Sheku they knew and loved had acted out of character, and if he broke the law, then the police had a right to act. But the family fundamentally believed that any force used had to be reasonable, legitimate, and proportionate. Under no circumstances did he deserve to die. Within minutes of Sheku's death, the family believed that misinformation began to be spread, not only information given to them directly, but also appearing in the media. Police sources painted an image of a large black man with stereotypical characteristics of extraordinary strength and dangerousness, wielding a machete to criminalise and to negate Sheku's right to life. Matters in relation to media and race will, of course, be dealt with in later chapters. However, some of those issues arose in this session, and the evidence of police officers and the descriptions of Sheku Bayo in the written material. In relation to the incident itself, Sheku was experiencing a mental health crisis and should have been dealt with as a medical emergency. According to the inquiry's reconstruction timeline, the first police van to arrive at Sheku Bayo stops at 7:20:23 hours. The police then shout at Sheku.
Response from that.
Do you want to demonstrate the level of shouting that you were adopting?
I don't know if it'll. Is it all right to shout in here?
I'd appreciate if you would demonstrate that.
So obviously we're speaking just now, but if I was out on the street, it would be, get back, stay where you are!
No, is that okay? By 7:20:29, two people were visible and moving near the rear passenger side of the police van. This may indicate that Sheku Bayo had been sprayed within 6 seconds of the car first arriving and the officers getting out. There was no standing back and assessing the situation. There was no reporting back to the control room. There was no consideration given to the fact that this was a man whose actions were consistent with being in a mental health crisis. An observation which was made by people in their cars, by his neighbour, and indeed by the police themselves. A person is seen falling over and then, quotes, there is some coming together and another falls, quotes, indicating that Sheikh Abayo was sprayed 3 times, hit with a baton and forced to the ground within 40 to 50 seconds of the first police car arriving. Sheikhu was brought to the ground in less than 45 seconds of the first police contact, never to get up again. Sheikhu was not 6 foot plus, he was 5 foot 10 inches and he weighed 12 stone 10 pounds. The first 2 officers who dealt with him were, however, 17 and 25 stones, and both 6 foot 4 inches tall. We provide written submissions in some significant detail about restraint and about the cause of death. But in relation to the latter matter, as my learned friend has already indicated, there is a consensus on the cause of death. Mr. Bayo, who suffered multiple injuries, was pronounced dead in hospital an hour and a half after first contact with the police. In contrast, none of the police suffered physical harm requiring significant medical attention that day. The families with the benefit of evidence heard during the inquiry understand that Sheikhu was in the throes of a mental health crisis. The process and procedures put in place to allow for assessment of a person in a mental health crisis were ignored. His safety was not considered. He ought to have been met with careful consideration and assessment. Instead, Sheikhu was met with immediate verbal, then physical violence. The reasoning for these actions given by PC Alan Payton was in the following terms. I was straight out of the passenger side door of the van and I immediately took out my CS spray out of my vest. I continued to think that he may still have been in possession of a knife and I wasn't taking any risks. As I have already said, I was still conscious of the fact that just because I could see his palms, he might still have the knife in his waistband or secreted somewhere about his person. With my spray in my right hand and pointing in the direction of the man, I shouted loudly and very clearly, "Get down on the ground." The guy was walking towards me and completely ignored me. He kept walking with his palms out, and I remember thinking how crazy he looked, as if he was on a mission. I was in genuine fear for my life at this point. I pressed my red emergency button and shouted loudly and clearly, "Get down on the fucking ground." My shouting and my pointing of my spray had absolutely no bearing on him, and he kept walking towards me, ignoring me, as if he was in a one-track mind. I was terrified, and I thought I was going to get attacked by him. Now, the question is asked now. I would like to ask you some questions about that paragraph. You've told us today about your spray and shouting the commands. Now, earlier today you talked about communication, and I'm interested. You also say in your inquiry statement you had been trained in de-escalation procedures, and I'm quite interested in finding out. There's no mention there of communication in the sense of a conversation, or, and then the answer, it wasn't the time for a conversation. Right, so you felt there wasn't time for that? Answer, it wasn't the time or the situation for a conversation. Question, oh sorry, it wasn't the time, right? Answer, yes. Question, is that because of the circumstances you have told us about earlier? Answer, yes. So do you think that there was time to ask him any questions like, are you okay, or anything like that? Answer, it's not the situation for asking questions like that. The man was out of control. The man was drugged up. The man had a big knife. He was using it. He was attacking cars. I needed firm control from the word go, and then once he is in cuffs, then asking him if he is wanting a cup of tea or that, but not at that stage. The incident has been described as a violent confrontation. It was the officers who initially offered violence to Sheikh Obayo. On arrival at the scene, he walked with his hands outstretched in front of him, a non-violent, non-threatening gesture. He did not say anything which might suggest he would offer violence. He did not have a knife in his possession. He did not pose a risk level necessary to engage with him in the way that he did. Instead of acting in accordance with their instructions, or their own standard operating procedures, and follow the UK-wide recognised force continuum model, through their own actions they escalated events beyond that which was necessary. They failed to follow the very reasonable option of containment suggested by Professor Edelsten. We heard from experts on how people in a mental health crisis should be dealt with, to stay calm and to give the person space so as not to put them under pressure, to express empathy. As set out by Professor Edelsten in his report at paragraph 22, quotes, "If the first police officers on the scene had realised that Mr. Bayo was psychotic, consistent with their observations that he was ignoring them and looking crazy, and had followed Police Scotland advice for dealing with psychotic patients, the outcome might have been different. Ideally, open and empathetic questioning, while offering Sheikh Obayo a space to keep walking, might have calmed the situation and prevented the attack or the need to restrain him physically until submission. In the meantime, an ambulance could have been called to help take Sheikh Obayo to hospital. If this conservative approach had been ineffective, a combined physical and chemical restraint approach would have been necessary. At the very least, an ambulance and paramedics should have been present when physical restraint was initiated. This would have allowed paramedics to rapidly gain intravenous access to administer sedative diazepam and/or haloperidol under guidance, if necessary, from the local emergency department. At best, restraint could have been delayed until a doctor had come urgently from the emergency department to help control the situation, allowing the administration of fast-acting ketamine. We know that if Sheikh Obayo was treated in a calm and considered manner, the outcome could have been completely different. Only a short time before the police arrived at Hayfield Road, Sheikh Obayo had a conversation with his neighbour, Mr. Neil Morgan, who treated him with consideration, care and kindness. And although it was clear to Neil Morgan that Sheikh was, quotes, was not himself, close quotes, he was able to speak to him, to reason with him, to get him to respond, and invited him into his house for a coffee. He offered what Sheikh needed: help. It has been suggested that Mr. Bayo repeatedly stamped on a female police officer. For the families, no credible and reliable evidence has been presented to prove this. Rather, the absence of significant forensic evidence and the absence of medical evidence supports the proposition that this stamp or stamps did not happen, and Officers Tomlinson and Walker ought not to be believed. The evidence of independent witness who saw what happened from his window and did not see the stamp as described by these officers ought to be preferred. Mr. Bayo was battened to the head and brought to the ground. As soon as reasonably practical thereafter, communication should have been made to the control room to get an ambulance to the scene. This was not done until it was too late to save him. Thereafter, the police carried out a method of restraint that they have been trained to understand is dangerous and carries with it a foreseeable risk to life. It is well recognised that the method of restraint used can produce life-threatening positional asphyxia. Whilst he was on the ground, Sheikh was restrained and forced face down, where he was handcuffed and leg restraints were applied to both his knees and ankles. 6 officers were involved in restraining Sheikh, and during the time he was face down, 6 officers lay on top of Sheikh, crossing over him from both sides and covering his whole body. The first 2 officers, Peyton and Walker, as already described, had a combined weight of 42 stones. The combined weight of 6 officers involved in the initial restraint was 446.7 kilogram, which is 86 stones and 2 pounds, which is over half a tonne of body weight in Sheikh Bayo. One officer used a baton to hold Sheikh down by pushing it in his body, and other officers were also seen to be using their body weight in order to restrain Sheikh by placing themselves on his upper back, shoulders and neck area, and by using their knees to hold him down. Sheikh, positioned lying on the ground face downwards and a high degree of pressure applied to his trunk, his breathing became restricted and stopped. Mr. Bayo died in hospital, covered with a number of injuries, including petechial hemorrhages to his eyes and a fractured rib. The issue of race flows as a river through this inquiry. We cannot address the woeful lack of training available and the attitudes of police officers, whether conscious or unconscious, in biases in these submissions. But we have been asked to flag up evidence which we rely on in the future. At the start of this inquiry, Senior Counsel for the Chief Constable made an opening statement on behalf of Sir Ian Livingston, in which it was stated that they were sending a very clear and strong and clear message that if you hold racist, misogynist or discriminatory views, you're unwelcome in policing. The Chief Constable declares that upholding the core values of Police Service of Scotland demands that it be anti-racist. This statement was welcomed by the families of Sheikh Bayo, as they hoped it would shine a light on the actions of Police Scotland on the 3rd of May 2015 and in the days, weeks and months in years that followed. In May of this year, 2023, the Chief Constable of Police Scotland went one step further from his opening statement a year earlier, in that he accepted that Police Scotland was institutionally racist. This declaration was welcomed by the families of Sheikh Bayo as something that the Black, Asian and minority ethnic communities had, in fact, known for decades. However, in the case of Sheikh Bayo, it will be submitted that in a combination of overt and covert racism of police officers, combined with institutional racism and unconscious bias, there was a thread that weaved through the moments from Sheikh Bayo meeting the police until he met his death, until the Lord Advocate made a decision not to prosecute. Whilst this is very much welcome, the response of those representing the rank and file exposes the wide chasm of opinion in the police force in relation to race. When speaking about the impact of the comments would have made on police morale, David Threadgold, chair of the Scottish Police Federation, said, "The use of the phrase institutionally racist is one that has deeply offended and upset them, and they do not recognise themselves in that way." It is noted that in his opening statement, Senior Counsel for PCs Kayleigh Good, Alan Smith and Ashley Tomlinson submitted that race did not influence their actions in any way. That view is reflected in the evidence of the officers who have given evidence before this hearing. However, several significant race issues arose, not only in relation to the actions of officers, but more broadly in relation to racism within the police force. The following is only a small number of the various issues. The possible use of racial profiling or racial assumptions in considering this may be a terrorist incident. The fact that language was used that is common to racial bias and unconscious racism. The perceptions of the black men being seen as larger or more aggressive, such as, "He was the most muscular man I have ever seen," and "He was massive and is the biggest male I have seen." The fact that officers either did not know or did not understand the use of offensive language, like coloured, language which was described over 20 years ago by the Stephen Lawrence Inquiry Report, paragraph 6.3, as use of inappropriate expressions such as coloured or Negro fall into that category. The use of such words, which are now well known to be offensive, display at least insensitivity and a lack of training. A number of officers used such terms, and some did not even during the course of their evidence seem to understand that the terms were offensive and should not be used. We note that this report came out in February 1999, almost a quarter of a century ago. The fact that we heard officer after officer say what could be described as a colourblind approach, an approach which is outdated and wholly fails to take into account unconscious racial bias, a matter which Police Scotland, does not understand. If officers were to be believed, for example, there was a lack of knowledge of black men dying in police custody being a particular issue. The fact that racist comments about ISIS were made and caught on TV. The fact, for example, despite the acknowledgement of senior officers about the evidence of a WhatsApp group which had racist, sexist and homophobic language, where every police officer said if they saw racism they would call it out and or report it, yet none of the officers involved in such groups appear to do so. In submissions, we address where we say that some officers have not provided credible and reliable information to this inquiry, that they have lied. We say that this reflects the experiences of the families of Sheikh Abayo, who say they were lied to and not told the truth by officers about the death of their loved one when they were spoken to after he died. The living reality for the Bayo family is that 5 days of protests for Floyd George in the US delivered more than 5 years of waiting for the Scottish criminal justice system to act. For the families of Sheikh Abayo, it is imperative that this inquiry proceeds with the utmost diligence and care, taking account of all of the relevant evidence. And the family remain committed to uncovering the truth, no matter how difficult or uncomfortable that may be for the institutions of our criminal justice system, which stand accused of failing Sheikh Abayo and his family. In Scotland, a society begins to wake up to an institutionally racist police force and racial injustice. The families hope that this inquiry will be robust in its analysis, searching out and recognising the existence of racism as a factor in the death of Sheikh Abayo. Sadly, Sheikhu is not by any means the first black man to die in police custody, but his family still have hope that his name does not fade from memory, and that one day the name of Sheikh Abayo leaves us a legacy of change, and that his son Isaacs and Tyler can be proud of. Those are the submissions on behalf of the Sheikh Abayo families.
Thank you, Ms Mitchell. I think we'll take a break now and sit again at 11:15. Now, on the behalf of the Chief Constable of the Police Service of Scotland, Ms Maguire.
Thank you, Chair, for this opportunity to make interim closing submissions on behalf of Sir Ian Livingston, QPM, the Chief Constable of the Police Service of Scotland. Written submissions on his behalf were submitted to the inquiry on the 23rd of June. These are adopted and they will be made available to the public by the inquiry. Today, I will only address one part of those submissions. Because of its importance to policing in Scotland and public confidence in the police, I will focus on the chapter which deals with the issue of race. Before doing so, the Chief Constable has asked that I, once again, address the families of Mr. Bayo. The Chief Constable is aware that you have attended every hearing from May last year and that you have required to listen to difficult evidence about your loved one, Sheku. You are at the heart of this inquiry, and the Chief Constable wishes to acknowledge the courage, the strength, and the dignity you have shown throughout. The Chief Constable made a commitment to you in his opening statement. When he expressed his support for this inquiry, he affirmed the mission of Police Scotland to improve the safety and well-being of the people and communities of Scotland, including your community, and to do so for the benefit of all citizens. He wishes to reassure you of the positive steps that have been taken in honouring that commitment. The Chief Constable has continued to support the inquiry with absolute candour. He has engaged bespoke resources to provide extensive material and position statements to the inquiry to assist the inquiry in all its aims. He has supported the inquiry in its investigation to understand what happened in Kirkcaldy on the 3rd of May 2015, and through operational organisation, he has facilitated the attendance of officers of Police Scotland to ensure that they have been available as and when the inquiry has needed them. Like you, the Chief Constable is determined to support the inquiry to ascertain and understand fully what happened that day. Organisational learning systems have been developed to respond to the evidence given to the inquiry. Lessons have been learned, continue to be learned, and there will be a constant striving for continuous improvement. He wishes to reassure you that your experiences have been heard and are informing changes in police practice and procedure and are building awareness. Although not a matter upon which submissions have been invited, the Chief Constable wishes to state publicly regret for the manner in which the news of the death of Sheku was conveyed to you. This can only have added to the shock and distress for you at the most terrible of times. The officers who gave evidence on this matter were clear that they wish they could have done things differently. The Chief Constable shares that view, which is why Police Scotland is now reviewing and redeveloping the training for communicating with families in tragic circumstances. This forms part of Family Liaison Officer training, but the Police Scotland Learning, Training and Development Department is now reviewing this from the point of view of probationer and detective training. I turn now to address the inquiry on the question of race. In his opening statement on the 11th of May last year, the Chief Constable focused on the issue of racism and policing in Scotland. He did this as it is vital to do so to maintain and enhance public confidence in the police. He committed Police Scotland to being anti-racist. Since that opening statement, significant work has continued and programmes are in place to further the anti-racist strategy, to ensure that there is no place for racism in Police Scotland and that racism is addressed and challenged at every stage and at every level. On the 25th of May this year, in an address to the Scottish Police Authority, the body to which Police Scotland is accountable, the Chief Constable acknowledged that institutional racism, sexism, misogyny and discrimination exist, and that Police Scotland is institutionally racist and discriminatory. What I propose to address in these oral submissions under 6 headings is the following. 1. The meaning of institutional racism and why it was recognised as being present in Police Scotland. 2. What the acknowledgement of it means for members of Police Scotland as individuals. 3. The consequences of the acknowledgement for the position of officers involved in this public inquiry. 4. The response to the acknowledgement. 5. What is being done by Police Scotland to address institutional discrimination. And finally, what the acknowledgement means for the communities of Scotland. So turning to the first heading, the meaning of institutional racism and why it was recognised. An organisation cannot simply declare itself to be anti-racist. It requires to develop policies, structures, and systems followed by actions to deconstruct racism and address issues of power, justice, and inequality. It requires to address and challenge the existence and workings of racism at personal, cultural, and institutional levels. It is an intentional approach and includes a challenge to all contributing forms of racism, including historic causes and systemic failures. This means that there has to be a collective effort to be permanently proactive and accountable for the prevention of discrimination, the advancement of equality of opportunities, and fostering good relations between people who share a protected characteristic and those who do not. Any public body, such as the police service, has a legal duty as well as an ethical and moral imperative to have regard to the issue of institutional racism, to be on guard for it, guard against it, and address it. This can only happen if there is a clear understanding of what it is and what it means for an organisation and the consequences of failure to address it openly and transparently. The meaning of institutional racism was given by Sir William Macpherson in the Stephen Lawrence Inquiry in 1999, and it is the collective failure of an organisation to provide an appropriate and professional service to people because of their colour, culture, or ethnic origin. It can be seen or detected in processes, attitudes, and behaviour which amount to discrimination through unwitting prejudice, ignorance, thoughtlessness, and racist stereotyping which disadvantage minority ethnic people. The Macpherson report emphasised the particular need for police organisations to be aware of the manner in which they communicate and interact with members of communities having regard to their specific needs. The Chief Constable considered that it was essential that Police Scotland examine the issue of discrimination to a standard which the public have a right to expect. It was a moral, and a legal duty. The assessment had to be mature, candid, humble, reflective, relentless, robust, and fearless. Acknowledging institutional racism means recognizing that discrimination rooted in racism is not to be seen as isolated individual acts, but is often possible because of institutional failures. This is not to lose sight of the importance of recognizing and addressing explicit racism or direct discrimination. However, a personal act of discrimination cannot be properly understood out with the institutional setting in which that act has been thought to be acceptable by the perpetrator. Discrimination is institutional when institutions are not doing enough or are not doing well enough at preventing discrimination and promoting equality. It is important to be aware of the intersectionality of all forms of discrimination. One person can suffer discrimination for more than one reason. For example, they can be exposed to racism and sexism, or racism and homophobia, or racism and disability discrimination. The Chief Constable's recognition of institutional discrimination is not confined to racism. There is a clear understanding that there is a need to be aware of and to address the intersectional effect of discrimination. And the Chief Constable gave the police authority an unequivocal commitment to the recognition of intersectionality when looking at the needs and sensitivities of individual members of communities served by Police Scotland. To be an anti-racist organisation, there has to be a recognition that addressing the question of institutional racism is a dynamic process. Police Scotland, as an organisation, has become better informed about racism, the causes of racism, and what an organisation needs to do to be anti-racist. Racism in our culture is as a result of slavery and colonial power. It is necessary to deconstruct this and bring about truly transformative change. Addressing institutional racism acknowledges history, power, and existing privilege. The term institutional racism, addressed properly in an informed way, is therefore a guiding principle. It is a commitment to the duty not to lose sight of what is required for an organisation to work towards anti-racism. In order for those who have experienced racism to begin to have experiences that are more positive, and for them to feel confident that those experiences of racism that had not previously been addressed will not be repeated. Yet, it seems that an acknowledgement by an institution that it is institutionally racist could at times be sensational and denote only failure and shame. This appears to have resulted in organisations being reluctant to engage properly with the question of the existence of institutional racism and be fearful of it. The Chief Constable acknowledged, frankly, his own initial reluctance when he made his statement to the police authority, when he said this: institutional racism, sexism, and institutional discrimination have become iconic terms in the vital battle to tackle injustice. Police officers and staff, including police leaders, can be conflicted both in acknowledging their existence and in using such terms, fearing it would unfairly condemn dedicated and honourable colleagues, or that it means no progress has been made since the 1990s. He recognised and understood that conflict because he had experienced that conflict himself over a number of years. He shared the reservation and concerns about acknowledging that institutional discrimination exists in policing. However, the Chief Constable was aware that there is considerable power in accepting the existence of institutional racism as properly understood, because only then can one assess how real change can be effected throughout the organisation for it to be truly anti-racist. The Chief Constable was acutely aware that given the essential role policing has in society, he had and has a duty to lead, uphold and inspire change that improves the experiences and lives of the public served by the police in Scotland. Addressing the issue properly is a fundamental requirement of the equality duty. Not to value the meaning and importance of institutional racism is to be underinformed of the social construct and the world in which we live. The Chief Constable made a commitment to listen to the experiences of the families of Mr. Bayou and members of the community. Having heard the evidence to date, he was satisfied that a proper and fair assessment of the organisational learning and awareness, as at the 3rd of May 2015, in the recently formed Police Service of Scotland, was such that there was a systemic issue. This was apparent from the evidence of the families of Mr. Bayou, the evidence that some diversity training did not appear to have been retained, and importantly, in the fact that there appeared to be a lack of awareness of some officers of the importance of not treating everyone the same. That approach to equality fails to address cultural needs, sensitivities, and concerns of individuals. He also had evidence from independent review and internal truth to power sessions that made it clear that discrimination within Police Scotland was, regrettably, a reality. Failure in training and systems means that it is an institutional matter. It is a failing of the organisation and not individual officers. For these reasons, the Chief Constable acknowledged, without reservation, that Police Scotland would come within the definition of institutional racism set out by Sir William Macpherson. This acknowledgement was essential to ensure that Police Scotland adheres to its core value of anti-racism. Any omission to recognise this in the face of the facts would wholly undermine the aims of Police Scotland to be anti-racist. Such a refusal would lack credibility. Arrogant, defensive, semantic, or ill-informed denial of the existence of institutional racism only obstructs progress and serves no legitimate purpose. If a body does not acknowledge institutional racism, how can it work towards becoming anti-racist? Police Scotland was the first UK police service to introduce a code of ethics, and that will now be made law. All officers required to take a statutory oath of office, which includes a pledge to discharge their duties with fairness, integrity, diligence, and impartiality, to uphold fundamental human rights and to accord equal respect to all people. It is therefore right that he, as Chief Constable, ensured that Police Scotland continued to lead the way and took this essential step to being an anti-racist service. The Chief Constable has been part of the leadership team since 2012, prior to the recreation of the Police Service of Scotland. He is accountable for the organisation. The work to address issues of racism and discrimination in Police Scotland was undertaken before the start of this public inquiry. The acknowledgement of institutional racism at the meeting of the Police Authority was possible only because of the reflective approach taken by the organisation under his leadership, which has led to more knowledge and understanding. In accepting that institutional racism exists in the organisation in which he serves and which he commands, the Chief Constable has chosen a new way, one that is more productive and effective. He has chosen transformative change. The acknowledgement was one which was proper for him as Chief Constable to make, under his command, with his informed understanding, and following his commitment to effect change. It will allow successors to the office of Chief Constable of Police Scotland to continue on a clear path for the organisation to achieve a new level of performance for all the communities it serves and to be anti-racist. So moving on to the second heading, which is what the acknowledgement means for members of Police Scotland as individuals. In his statement to the Police Authority, the Chief Constable made clear the distinction between individual officers and the collective responsibility of the organisation. It absolutely does not mean that all Police Scotland officers and staff are racist or sexist. The Chief Constable has great confidence in the character and values of the people in Police Scotland, and he was clear that it is an institutional matter for which he, as leader, has taken responsibility. But the Chief Constable recognised that the acceptance of institutional racism without discernment could lead to every individual member of the organisation feeling or being labelled as racist by those who misunderstand or misinterpret the definition. He understood that there was a risk that the acknowledgement could result in officers being accused of being racist because the Chief Constable told us that. He was aware that officers and staff would have to deal with that misrepresentation. And whilst he could not withhold the acknowledgement which had to be made, he wanted to be clear in his message to members of Police Scotland. All officers and staff have been given explanations as to what the acknowledgement of institutional discrimination means, and that is not the same as saying all officers and staff are racist. It is a candid recognition that the organisation needs to do more in respect of education, policies and practice to ensure that everyone gets the service that is their right. The Chief Constable calls on all officers and staff to reflect on their perceptions and understanding of the meaning of the acknowledgement. An extensive communications programme is in place within Police Scotland to facilitate understanding, listen to concerns and encourage engagement. Leaders have been tasked with communicating with officers and staff to address what the acknowledgement means for individual officers. Changes in behaviours are already taking place, with an observed confidence in challenging unacceptable behaviour in others. But it is necessary to address heading 3, which is the consequences of the acknowledgement for the position of officers involved in the public inquiry. The acknowledgement is in relation to the organisation only. The issue as regards individual officers must, in fairness and having regard to the terms of reference of the inquiry, be determined by the Chair. Nothing that was said in the Chief Constable's statement to the authority or to the inquiry about the organisation should be taken as any comment on whether the actions of any individual officer whose actions are being examined by this inquiry was influenced by race or perceived race, and that's particularly so of those who are core participants. The position of any individual officer whose actions are being considered by the Chair should not be adversely affected by the acknowledgement of the Chief Constable regarding the matter as it affects the organisation. Turning now to heading 4, which is the response to the Chief Constable's acknowledgement. The acknowledgement by those informed of its purpose and intent including people affected by discrimination, has been welcomed within policing and across society. Support for the Chief Constable's position was articulated by Semper Scotland, the primary staff association which exists to support and represent all minority and ethnic officers and staff within Police Scotland, who said, "We stand with our Chief Constable in his courageous acknowledgement of institutional racism within Police Scotland. We recognise that work needs to be done to create a truly equitable society and will support efforts towards that goal." The Chair of the Scottish Police Authority, Martin Evans, in support and in recognition of the work which lay behind the statement, said that it is the crucial next step for effective organisational development. He said that the authority is confident that this marks that moment for policing, one that moves the focus from continually describing problems within Police Scotland to how it changes. The Vice Chair of the External Independent Reference Group, Chris Cregan, in his address to the Police Authority, said that Police Scotland's intention and commitment has integrity and substance. The fact that this was a judgment by the police service of itself was a huge strength, a watershed moment, and that the impediment to change had been removed. Aberdeen City Council carried a motion unanimously acknowledging how difficult it was for the Chief Constable to make his statement because of the lack of understanding of the terms institutional racism, sexism, misogyny and discrimination. It also acknowledged that the Chief Constable's statement did not suggest that any officer is prejudiced, but accepted that to improve Police Scotland as an organisation, initially a statement had to be made of the problem. The Council expressed its full support and thanks to all members of staff at Police Scotland for their work in immensely difficult circumstances and recognised their dedication and commitment to public protection. Leaders from across the political spectrum expressed public support, including the First Minister, Hamza Yousaf. The Scottish Labour leader, Anna Sarwar MSP, believed the Chief Constable's statement had progressed discussions about institutional racism and discrimination. He said, "We cannot pretend that institutional racism, sexism, misogyny and discrimination does not exist in many of our public organisations. And the first step to addressing that is to acknowledge it." He also noted that a large part of the Chief Constable's statement had been lost in the firestorm that followed. That firestorm is exactly the response which has made organisations reluctant to engage properly with the definition and leaders concerned to address it with the candour required. They risk personal attacks, such as have been made on the Chief Constable. True leadership means making hard decisions, facing harsh realities, and accepting responsibility without fear. However, it is vital that there is a shared responsibility of all of us in furthering the understanding of the meaning of the definition of institutional discrimination and why there has to be acknowledgement of such discrimination where it exists, if there's to be any hope of a society which is fair for all communities. The definition of institutional racism is a powerful tool and a standard with which to work. Shows clearly what needs to be changed in an organisation. It's the duty of the organisation to establish that this is a position of strength, maturity, forward thinking, and not a failure or indictment of every member. It is not a label to be applied in a pejorative way. It is a recognition of systemic issues in order for them to be addressed. It is a commitment to constant regard and review to enable the service to hold themselves to the standards required by the Macpherson Report, the Equality Act duties, and the Scottish specific duties under the regulations under that Act. It is a manifestation of the policing principles. The acknowledged authenticity of the Chief Constable's statement is reflective of it having been made from a position of proper understanding of what institutional racism is and of education in how it can be addressed effectively. Now that brings me to heading 5. What is being done by Police Scotland to address institutional discrimination? The public will no doubt be concerned as to what the acknowledgement means for Scottish policing in 2023 and for the future. Police Scotland has taken the Macpherson definition and used it as a blueprint for action. The issue of racism was already being addressed through evidence-based actions, effective leadership, campaigns, empathy building, positive narratives, awareness buildings, legal action and peer support. The very acknowledgement of the institutional nature of discrimination is part of the strategy to address racism. What has been described as the rotten apple approach does not address the fundamental root problem of the environment in which such individuals have been permitted to act. And this is why it is the institution which needs to acknowledge the root problem in order for it to be addressed. The major engine for change is the Policing Together Equality, Diversity and Inclusion Strategy, which the Chief Constable introduced in September 2022, when he stated the aim of that strategy, which is to build a society where everyone can thrive and flourish and collectively build a country where everyone knows they are safe and secure. The Policing Together strategy outlines the action Police Scotland is taking to champion equality and inclusion so that it tackles sexism and misogyny and becomes an anti-racist organisation. Deputy Chief Constable Fiona Taylor, QPM, is providing leadership to build and maintain a values-based organisation and to drive improvements demonstrating how policing in Scotland reflects, represents and serves all communities. The Chief Constable has created a new dedicated Assistant Chief Constable role to oversee the Policing Together strategy with bespoke organisational resources. Assistant Chief Constable David Duncan has been appointed to lead work in the implementation of the strategy. This is to give effect to the Chief Constable's commitment to Police Scotland being an anti-racist and anti-discriminatory service with a culture which reflects its values of integrity, fairness, respect and commitment to upholding human rights. Policing Together is a dynamic, integrated, coherent, long-term programme, the purpose of which is to embed throughout every part of Police Scotland the fulfilment of that commitment. It addresses what is needed in terms of ethos, commitment and action. There are 4 pillars which will underpin the work of the Policing Together programme going forward. They are mutually supportive and are used collectively and interactively on an evolving basis. And they are leadership, training, communication and prevention. Fuller detail of the Policing Together strategy is set out in the written submissions, and the inquiry will hear more evidence about this in due course, but I will mention some key points today. The Executive of Police Scotland has called upon all its leaders to live, lead, support and embed high standards, equality training and a focus on values by taking action, which includes building and maintaining professional standards and boundaries, publication of anonymised details of gross misconduct outcomes, equality and diversity training, and a communications campaign calling on Police Scotland officers and staff to know and live Police Scotland values. People entrusted with positions of leadership must lead the desired culture change. The public has a right to expect that any officer or member of staff employed by Police Scotland will be held to a high standard. Otherwise, Police Scotland cannot rightly ask them to have confidence in the service. Training will continue to seek to address racism, misogyny, and all forms of discrimination within policing in Scotland. Police Scotland recognises that the majority of officers and staff act in accordance with Police Scotland's values and standards every day. Police Scotland is aware that to continue to deliver excellent service in an ever-changing world, there is more the organisation can learn through continuous professional development. Training delivery for Policing Together has the depth of support available for colleagues at different stages in their career, ensuring all officers and staff have guidance on how they can role model and lead on the changes required, ultimately delivering the commitments made in the Policing Together strategy. The way police officers conduct themselves, both on and off duty, is fundamental to maintaining public confidence and essential to policing by consent. At the heart of Policing Together is the organisation's code of ethics, and from this the organisation derives a direct link to values-based policing, which reflects and represents all communities. In May last year, the Chief Constable reinforced the very clear message that if you hold racist or discriminatory views, you are not welcome in policing. The process for vetting at the recruitment stage has been reviewed, and re-vetting is being carried out on a systematic basis. These strategies are not projects to be announced with fanfare and which will have a finish date. They require continuing commitment to further the aim of Police Scotland to be an anti-discriminatory and anti-racist organisation, which will review, reflect, learn and change as required. Since the statement of the Chief Constable to the Police Authority in May this year, action has accelerated. With further understanding has come an even more focused drive to purposeful action. Police Scotland will ensure continued scrutiny of the effectiveness of the strategies as a crucial part of the perpetual commitment to anti-racism, the collective effort to be permanently proactive and accountable. Police Scotland will be aided and informed by external independent critical groups such as the Independent Reference Group and the Professional Reference Group. So I move on finally to ask the question and answer the question, what does the acknowledgement mean for the communities of Scotland? The recognition by the Chief Constable of the existence of institutional racism is intended to be a message of confidence in an organisation that is determined to be an anti-racist service and which is not afraid to face difficult questions. And it is right that this comes from a body with responsibilities for the safety and well-being of all communities. To the communities most affected, it is one of reassurance that it is not an empty statement to be made and then forgotten. It is not said just for today or for political expediency. It was not imposed upon Police Scotland. It is the organisation's reflective, purposeful statement and commitment. There will be no final point in Police Scotland's own assessment of itself against the Macpherson definition, and nor should there be. Racism is as a result of power imbalance. As history has shown, this can re-emerge. It is therefore continuing, robust, rigorous commitment which is required, and this is an integral part of the core value of being anti-racist. The power to address racism in policing is vested in every officer of Police Scotland. It cannot always be left to those who have suffered racism to bear the burden of trying to effect change, no matter how willingly they have carried it for so long. The burden has to be shared, and it is a collective responsibility of every one of us. To members of the Police Scotland community, it's also a message from their Chief Constable of confidence in all those who adhere to the core values daily, including that of anti-racism, and who are proud to do so. Those who embody individually and collectively the respect for the human rights of others, and fulfil their statutory obligation of protecting communities and keeping them safe. He is aware that police officers and staff do incredible things to keep all communities safe, demonstrating professionalism and these shared values. And he encourages every officer and member of staff to keep doing so and to show the true meaning of policing together for the benefit of all communities. A great strength of Police Scotland is that officers and staff are drawn from different backgrounds and experiences. What unites them is the shared and non-negotiable set of Police Scotland values. Only by working together will the organisation fulfil its aims. This recognition of the systemic issues which bring the organisation within the definition of institutional racism will undoubtedly have seemed to be a blow for all those dedicated police officers and staff who give up so much of themselves and their personal lives in their vocation to help others. It is not intended to be. This acknowledgement demonstrates the professional confidence of the organisation and is made with awareness and understanding of why it is necessary to make it to progress to be anti-racist. It is truly a sign of real progress, effective change, and the Chief Constable's belief in those professional, hard-working officers and staff of whom the Chief Constable is proud to serve alongside and to command. Under continued strong leadership, they are the ones who will ensure that Police Scotland will always be a police service in which the public can have full trust and confidence. And that concludes my submissions, Chair, with my thanks for the opportunity.
Thank you, Ms Maguire. Now, on behalf of Ms Short, PC Walker and the Scottish Police Federation, Dean of Faculty.
Obliged, my Lord. For understandable reasons, this inquiry has focused on the tragedy of the death of Mr Bayo. Nothing that I say today is intended to suggest that that death was anything other than tragic. But Mr Bayo's interests are not the only ones in play here. The events of 3rd May 2015 have had serious impacts on many others. I know that the inquiry will look at matters dispassionately and avoid the temptation to reimagine events with 2020 hindsight. In assessing what happened that day, as has been stressed in our written submission, it is important to recognise the fallibility of human memory. Witness gave their evidence to the inquiry 7 years after the event. It is crucial that one does not consider that evidence in isolation or uncritically. The best evidence here lies in the contemporaneous and unalloyed evidence found in the airwave transmissions, in the CCTV and dashcam footage, and in the post-mortem tests. It is there that the true picture emerges. And from that true picture, it is clear in my submission, beyond peradventure, that Mr Bayo voluntarily consumed a significant amount of illicit drugs with a clear and dramatic effect on his mental state. Having done so, he got into a fight with his friend Mr Saeed. The latter's performance at the inquiry was plainly unhelpful, but the state of the premises afterwards of Mr Morgan, there was a clear violent altercation between Mr Bayo and Mr Saeed, and the evidence of Mr Freeman means it is likely that Mr Bayo sustained his rib fracture in the course of that altercation. Mr Bayo then armed himself with a large knife and headed out into the streets of Kirkcaldy. We know this from the evidence of Mr. Morgan. We know this from the dashcam footage that shows Mr. Bayo carrying a knife. He was on the streets at 7:09 a.m. when he was first picked up on the dashcam. Having done so, Mr. Bayo then started to attack passing cars, provoking fear and alarm. The terrifying nature of what he was doing was clearly explained by the nurse, Ms. Limbert. By 7:15 a.m, Mr. Kohlberg and others were calling 999. Mr. Kohlberg reporting that Mr. Bayo was jumping out, trying to hit other cars, stopping vehicles, jumping on cars, jumping out in front of them. Everyone's having to reverse and turn around. A minute later, at 7:16 a.m, Police Constables Tomlinson and Short were asked to attend. They were told there is a male armed with a knife, African-looking male chasing someone, maybe carrying a knife, described as big with muscles, about 6 feet tall. Other officers were also deployed. Constables Walker and Payton encountered Mr. Bayo first at 7:20:13. Constables Tomlinson and Short arrived 26 seconds later. Mr. Bayo had by then discarded the knife, but all of the evidence indicates that officers require to proceed on the assumption that he remained armed. Nothing else would make sense. Matters escalated very quickly after that. PC Payton's emergency status was activated at 7:20:42, followed by PC Tomlinson's at 7:21:19. Within seconds, despite the deployment of CS gas and Pava spray, Mr. Bayo had violently assaulted then PC Short by punching her to the back of the head, propelling her to the ground. Mr. Bayo had been apprehended by 7:22:10. 14 seconds later, he was reported by PC Walker to be in cuffs, but still struggling. By 7:25:17, 3 minutes later, Mr. Bayo was reported by PC Smith to be unconscious, breathing but unresponsive. My Lord, none of that can seriously be disputed. It means that Mr. Bayo, doubtless as a result of self-intoxication, acted in a seriously criminal manner, creating a plain danger to members of the public that absolutely had to be addressed by the police. The crucial interactions with Mr. Bayo took place in the space of 5 minutes. To criticise officers who ran towards the danger he presented when the rest of us would run from it would be wholly unwarranted. Of course, the inquiry will want to look at events with extreme care, and in what follows I will address the main points that seem to be in contention. Firstly, should officers have waited before confronting Mr. Bayo? A number of suggestions have been advanced as to how Mr. Bayo might have been dealt with other than by confronting him. None bears scrutiny. A firearms unit was not available within a reasonable time, nor was a dog unit. Resort to either would have entailed leaving a man reported to be armed with a knife and attacking passing cars unrestrained for 20 minutes or more. Viewed through the eyes of the attending officers at 7:20 a.m. on the 3rd of May, that would have been unconscionable. It would have exposed the public to unacceptable risk. That leaves only the possibility of confinement at the locus. Any suggestion to that effect parts company with reality. Officers did not know in advance precisely where Mr. Bayo was. They encountered him randomly, walking briskly and with purpose through an open residential area, an area with multiple houses frequented by dog walkers. There was no realistic way in which the officers who encountered him might have confined him at the locus. We see that from what happened when they did engage with him. He did not respond to verbal commands. Instead, he advanced upon officers as they retreated in an attempt to keep distance. Bearing in mind the necessary assumption that he remained in possession of a large knife, this must have been terrifying. To propose that he should have been allowed to proceed on whatever journey he was on is, in my submission, ludicrous. To suggest he could meaningfully have been contained in the open space where he was found, without endangering passers-by, and in a manner that would have led to any other outcome, is equally fanciful. The stark fact of the matter is, Mr. Bayo presented, objectively, a high risk of danger to the public. That danger needed to be addressed. If Mr. Bayo had stopped when told to do so, we would not be here. He did not. He advanced on the officers, and they responded appropriately. And ultimately, in my submission, the true position is given by Mr. Graves. When he assessed the decision with the benefit of hindsight, he expressed the view that the officers did everything correctly: go to the scene, locate the individual, attempt to engage the individual. To stand off and not to engage would have created an unacceptable risk. The inquiry has heard evidence that Mr. Bayo was a kind, loving, friendly man who would help anyone who needed it. I do not suggest for a second that there is anything wrong or inaccurate in that description. That was not, however, the man who was on Hayfield Road on the 3rd of May 2015. With the benefit of hindsight, and solely with the benefit of hindsight, Mr. Bayo was suffering from a constellation of symptoms that would fall within the bracket of acute behavioural disturbance, likely prompted by drug-induced psychosis from the consumption of MDMA and alpha-PVP. None of the attending police officers share any responsibility for his consumption of those drugs. They share no responsibility for his acute presentation in light of that consumption, and they share no responsibility for Mr. Bayo obtaining a knife and roaming the streets of Kirkcaldy, placing members of the public at significant risk. It was Mr. Bayo and Mr. Bayo alone that caused a clear and pressing danger that simply had to be addressed. And it was addressed by officers doing their best in terrifying circumstances that unfolded in a very short period of time. The microanalysis that this inquiry will undertake is understandable, but it is done with the luxury of time and resource and absence of fear that were not available to the officers on Hayfield Road. The next step in the analysis is the decision to deploy CS gas and Pava spray. Here again, in my submission, any criticism would be unwarranted. Mr. Bayo was given clear, audible commands to stop and to get on the ground. We have heard today the video footage played of how loud that command was. He did not comply, and he did not comply doubtless because he was in a state of psychosis. He advanced upon officers who tried to retreat. That is precisely the sort of situation in which non-lethal measures, such as incapacitant sprays, are meant to be used. Regrettably, and again, no doubt because of the psychosis, those incapacitants did not work. Some of the evidence has suggested that a more passive response should have been adopted, to the effect that Mr. Bayo should have been asked if he was okay and offered a cup of tea. This again is wholly unrealistic. Police officers do not tackle violent knife crime by asking suspects if they want a cup of tea. In any event, we know what would have happened if something like that had been tried. It was tried by Mr. Morgan, to no avail. The suggestion that the police should have attempted a friendly chat is again not one that can be countenanced. Next, we have the decision to restrain Mr. Bayo. Mr. Bayo was restrained after, on the incontestable evidence, he had committed a violent assault on Ms. Short, a much smaller female officer who was running away from him. On any view, he punched her to the back of the head, propelling her to the ground. At that point, he absolutely had to be restrained. Ms. Short was on the ground in a situation of real peril. Her colleagues had to intervene. Was there a stamp? Much time and effort has been expended in exploring this question. On one view, it does not matter. Once Miss Short had been punched to the ground, Mr. Bayo needed to be restrained. There was no other option, whether or not he stamped on her. But I quite accept that evidence, clear evidence of a stamp has been given and disputed. It is recognised that the inquiry will need to consider that point. When it does so, in my submission, there is no doubt about it. Mr. Bayo stamped on Miss Short as she lay on the ground. Clear evidence of that stamp was given by PCs Walker and Tomlinson. The only eyewitness who said otherwise was Mr. Nelson, and we know from the evidence that his sightline was hugely impaired. He could have seen nothing below shoulder level, so it is hardly surprising he saw no stamp. The medical evidence comes nowhere close to ruling out a stamp. So much would turn on unknowns, such as the force of the stamp, where it actually landed, the protective effect of body armour, that the medical evidence is only of limited assistance. The inquiry may, however, find that the evidence of Mr. Crawford, despite severe challenges posed by counsel to the inquiry, is consistent with a stamp having occurred. But there is other evidence which puts the matter in my submission beyond any sensible doubt. Firstly, there is the soil evidence. How can it be, looking at matters realistically, that precisely the same soil type was found both on the sole of Mr. Bayo's boots and ingrained into Ms. Short's jacket? A situation which required the application of force and cannot have happened, as the inquiry has heard, by incidental transfer. That is a coincidence for which there is no sensible explanation other than the stamp having taken place. And secondly, and here I again return to the need to check any evidence against the known contemporaneous events, we have the airwave transmissions. The first indication of any cause for the concern of the well-being of Mr. Bayo came at 7:25:17 when PC Smith reported unconsciousness. Almost a minute earlier, at 7:24:24, Sergeant Maxwell initiated a call to control, and in that he can clearly be heard to say the following: although there's no visible injuries to PC Short, she's been stomped to the body a few times, etc., and struck to the head. Can you see if an ambulance can attend ASAP? At that point in time, within 4 minutes of the interaction with Mr. Bayo starting, there was no reason to think this was anything other than the routine arrest of a suspect. There was no reason to think Mr. Bayo might die. As he had punched Miss Short to the ground, there was no embellishment needed to justify the arrest. Accordingly, the question the inquiry has to consider is, if there was no stamp, how does one explain what Police Sergeant Maxwell said 4 minutes after the first interaction with Mr. Bayo and a minute before he was noted to be unconscious? To suggest that this was anything other than a report as to what had been observed by those in attendance makes no sense at all. The next point I would seek to address is the method of restraint. There is, in my submission, no sensible criticism of the way in which PC Walker brought Mr. Bayo to the ground. Thereafter, he was swiftly restrained. He was on the ground by 7:21, noted as being in cuffs by 7:22:24. At 7:23:13, DS Davidson described a big restraint, indicating that leg restraints would be necessary, doubtless because of the ongoing struggles of Mr. Bayo. Mr. Bayo became unconscious within 2 minutes. There is no suggestion of death by asphyxia. There is no question of anyone being anywhere near Mr. Bayo's neck. Contrary to what has been said in certain media, at no point did Mr. Bayo say, "I can't breathe." This was a violent male who we now know to have been in the grip of drug-induced psychosis, who needed to be arrested, who struggled violently against that arrest. The use of body weight to subdue him was entirely in accordance with training, and in the normal run of things, it would not have been expected to have any effect other than the subduing of Mr. Bayo. Next, should the police have acted differently as Mr. Bayo was in psychosis? There are two answers to this. First, there is no basis for a finding that officers should have been able to diagnose psychosis. They are not medics. They were tasked with dealing with a man with a knife. Even if they had medical training, this was still a police matter, not a medical one. If one wants to test that, I invite the inquiry to consider the evidence of Ms. Limbert, a staff nurse at the Victoria Infirmary. She was confronted by Mr. Bayo on Hayfield Road. Her reaction, with all her medical training, was not, "I'd best phone an ambulance." It was, "I'm phoning the police." In any event, even if the police had managed to jalouse psychosis, it would have made no difference. A man with a knife, and I repeat, that is the assumption they had to proceed on. A man with a knife needs to be stopped, whether or not he's psychotic. Indeed, particularly if he is psychotic. Someone who's psychotic, we know from the evidence the inquiry has heard, is not in mental crisis in the sense of being depressed. Someone who is psychotic cannot be reasoned with. Someone who is psychotic presents a clear danger to the public and needs to be stopped. As for the suggestion that an ambulance should have been attendance from the off, that cannot be accepted either. It is well known that the ambulance service is under unprecedented pressure. To require the police to summon an ambulance whenever a suspect is acting oddly or violently would be distinctly unhelpful. Next, the actions once Mr. Bayo became unconscious. Officers have basic first aid training. They followed this to the letter. Mr. Bayo was placed into the recovery position. Once he stopped breathing, CPR was started. An ambulance was called as soon as concerns arose. There is no realistic criticism of what happened after the loss of consciousness. Why did Mr. Bayo die? There were multiple reasons for the death. He would not have died if he had not been restrained by the police. That much is clear. But he would also not have died if he had not taken illicit drugs, if he had not armed himself with a knife, if he had not created a situation in which he needed to be restrained, if he had obeyed lawful commands to stop, if he had not assaulted Miss Short, or if he had not continued to resist arrest so violently. He was not killed by the police. He died because he created a situation in which he had to be restrained and where he was unable to survive lawful restraint. My Lord, by way of brief conclusions to this oral submission, this was, as I've said already, a tragedy. It was a tragedy for Mr. Bayo and his family, of course, and I do not seek to downplay that in any way. But it was also a tragedy for Ms. Short, who has lost her career and whose only involvement here was to be the victim of a violent assault. It was a tragedy for the other officers who have been lambasted in the media and under the microscope now for over 8 years. The first and overriding duty of a police officer is the protection of life. Whatever virtues Mr. Bayo displayed previously, on 3rd May he acted in a manner that posed risk to life. He took illicit drugs to the point of psychosis, armed himself, took to the streets, attacked passing cars, and terrified the public. He created the situation that led to his death. He assaulted a female police officer and created a situation in which he had to be restrained. No one involved wanted Mr. Bayo to die. They only wanted him to cease and desist, but he struggled to the end. The anger of the family is understandable, but it is misdirected. The stark reality of the matter is that everything that happened between 7:20 and 7:25, and it really is that tiny window of time that matters, was brought about by what Mr. Bayo had done before then and his interactions with the police thereafter. Everyone is sorry that Mr. Bayo is dead. It is a death that no one intended, that no one relishes. It is, as has been repeatedly recognised, tragic. But it is not a tragedy for which those I represent bear any responsibility in law or in morality. They did their duty. They responded to a situation that needed to be addressed. They dealt with a rapidly escalating incident to the best of their ability and in accordance with their training. The duty of a police officer is not to be perfect. It is to act reasonably and in accordance with the law. On any view, they did just that. And as a final observation, if I may, I would urge the inquiry to bear in mind the law of unintended consequences. It is all too easy, hearing matters in intricate detail and with the benefit of hindsight, to try and imagine convoluted scenarios in which matters might have proceeded differently. This was a dynamic situation. As soon as officers engaged with Mr. Bayo, matters unfolded rapidly. There was little opportunity to do anything differently. That might lead the inquiry to consider whether officers should have held off in the first instance. That would be a very dangerous suggestion to make. The risk of defensive policing is clear. The dangers of a lone individual acting aggressively and erratically, reported with a knife, are equally clear. If one needs an illustration, consider the example provided by Ms. Caffrey. She held her team off from attending a knife incident, and when they eventually went in, they discovered an arterial bleed. Given how quickly such a bleed will lead to exsanguination, her decision to delay even by a few minutes may well have led to that arterial bleed. That is indeed what happens if police officers are mandated to hold off and not engage. People die. For that reason, this inquiry must take extreme care not to make recommendations based on a minute reassessment of the dynamic events of 3rd May, which, rather than addressing the understandable concerns arising from the death of Mr. Bayo, instead put officers and members of the public at greater risk. That would be an even greater tragedy than the one that brings us here. My Lord, I'm obliged.
Thank you, Dean. Now, on behalf of Mr. Payton, Mr. McConaughey.
On behalf of Alan Payton, we adopt the written submissions lodged on the 23rd of June 2023. They contain our submissions with regards to the conclusions the Chair should reach based upon the available evidence, both oral and written. It is important for the public to understand that the Chair's findings will be based on that evidence and the facts he may infer therefrom, and not on the unsubstantiated narrative so often fed to the media over the past 8 years by those with an interest to do so. Whilst our only interest involves Alan Payton, understandably points made by others representing officers relating to some of the issues may also be relevant to him, and no doubt, if appropriate, the Chair will have regard to those. In summary, we consider the evidence has demonstrated that Sheku Bayo voluntarily ingested illegal drugs and alcohol on the evening of the 2nd of May and into the early hours of the 3rd of May. That this cocktail caused him to act in a strange, concerning and paranoid manner which was a type of behaviour he had previously exhibited when taking illegal drugs. In the early hours of the morning, he left the company of his friends in such a manner that his best friend, Mr. Saeed, left to go after him to make sure he was okay. When he caught up with Sheikh Ubayu, he was not prepared to be reasoned with, nor was he prepared to be calmed down. Mr. Bayu violently attacked his best friend, punching him repeatedly to the head and attacking him with a weapon in the form of a clothes pole. As a consequence, his best friend ran away to escape the violence and was so concerned that he contacted Sheikh Ubayu's partner. Mr. Bayu then went to his home and armed himself with a large kitchen knife and went out into the public streets. Nearby, he met a neighbour whom he knew, who offered to help him and who invited him into his home. Sheikh Ubayu refused the offer of assistance and indeed poked that neighbour in the stomach with the knife. Neither his best friend, Mr. Saeed, nor the neighbour who knew him saw reason to call for an ambulance because they felt he was suffering from a mental health crisis. Mr. Bayu then strode off and was seen by numerous people who were alarmed by the sight of a powerfully built man striding with a purpose early on a Sunday morning, armed with a large kitchen knife. As a consequence, a number of them telephoned the police. Alan Payton was one of the first officers on the scene. He and his colleague had reasonable grounds to suspect that Sheikh Ubayu was armed with a potentially lethal weapon. It appears, however, on the evidence, the knife had been discarded moments before Mr. Bayu came into contact with the police. Alan Payton issued instructions to stop, which were ignored. As a consequence, he discharged his CS spray, most of which, it appears, blew back into his own face and incapacitated him for a period when he had no idea what was taking place. By the time he had recovered sufficiently, Mr. Bayu was already on the ground, being restrained by officers. He, Sheikh Ubayu, having assaulted PC Short, albeit that was unknown to Mr. Payton at the time. Alan Payton's involvement in the restraint was to put his baton forcibly across Sheikh Ubayu's bicep. The restraint was of short duration, and during it, Alan Payton played what might be seen to be a peripheral role. When it became apparent that Sheikh Ubayu was unconscious, Alan Payton attempted to assist his breathing, and in all likelihood, the injuries subsequently seen around Sheikh Ubayu's mouth were caused during the efforts to save his life. Mr. Bayu died as a result of a combination of his drugs intoxication while struggling during what is submitted to have been a lawful restraint. The other injuries he was later found to have were minor and did not contribute to his death. Various suggestions were made from various witnesses about other options which could have been tried in an effort to de-escalate the situation. It is submitted that whilst no doubt theoretically possible, these were unrealistic in the real world and in the particular circumstances that pertained here. Indeed, with hindsight, it would be reasonable to conclude that any such attempts may well have resulted in potentially serious injury to an officer or any member of the public who had happened upon the scene. of the last 2 people who had interacted with Mr. Bayou, both of whom he knew and presumably trusted, one was left battered, bruised, and running for safety, whilst the other had a large kitchen knife poked into his stomach. The effect of Sheku Bayou's interaction with his neighbour, who offered him assistance, was for Mr. Bayou to head off armed with the large kitchen knife, threatening members of the public and attacking their vehicles. On the issue of race, which featured certainly in the questioning of Mr. Payton, if there was a thought on the part of anyone that this inquiry was anticipated to reach a predetermined conclusion about the police, racism, and its part in this incident, then the announcement by retiring Chief Constable Sir Ian Livingston regards institutional racism in the police did nothing to allay those fears. Its content, and particularly its timing, having regards to this inquiry and the terms of reference which it has, frankly astonished Mr. Payton, and as we understand, many of his colleagues. He considers that the Chief Constable threw a skunk into the room while swiftly closing the door behind him. This inquiry will no doubt in due course, on the basis of the evidence which it chooses to hear, reach its own conclusion about institutional racism. Irrespective of that, however, the evidence to this inquiry has disclosed nothing to support any contention that Sheku Bayou's race or perceived race had anything at all to do with this incident. Despite repeated and detailed questioning of the officers involved, particularly Alan Payton, not a shred of evidence has been led to support such a conclusion. In particular, it is submitted that the historical complaints relating to Alan Payton's service as a police officer are wholly irrelevant. The other allegations came from disaffected family members who have used the Bayou family as a vehicle for their own issues. Although Alan Payton was questioned about these allegations, their evidence has never been tested, and any suggestion about obtaining other evidence from people who knew Alan Payton, both personally and as an officer, has been discouraged. Despite any evidence, Alan Payton has effectively been on trial for the past 8 years through the media and on social media. This inquiry has heard no credible and reliable evidence to substantiate the allegations repeatedly made against him. Furthermore, and arguably more importantly, there is no evidence at all to support any contention that Sheku Bayou's race or perceived race played any part in the decisions he, Alan Payton, made on the morning of the 3rd of May. We submit that the evidence demonstrates that Alan Payton did nothing wrong. He went out that morning on a shift like any other and has not worked since. The toll on him and his family has been immense. The inquiry has the medical evidence to substantiate that, and indeed, it is submitted, has seen it itself from his own evidence and the way in which it was given. As the Leonard Dean of Faculty has already mentioned, we, the public, run from danger, and various members of the public ran or drove away from the danger that Sheku Bayou posed that morning. However, our police force, in the execution of their duty, need to run towards the danger we are running away from. Alan Payton and his fellow officers did that. The death of Sheku Bayou was an unforeseen tragedy, but the reality is that on the evidence before this inquiry, he was to a very significant extent the author of his own misfortune. The police, including Alan Payton, were faced with a dynamic set of circumstances where decisions had to be taken as a matter of urgency, where the safety of the officers and the public was paramount. On the evidence, the decisions taken were rational and reasonable and were to no extent whatsoever motivated by race. Those conclude the oral submissions on behalf of Mr. Payton.
Thank you, Mr. McConaughey. Now, I'm mindful of the need to give the stenographer a break, so what I'm going to do, I think the best plan is to stop for lunch and try to sit again at 10 to 2.